Attorney fees and probate. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover the notice regarding attorney fees, one of the mandatory forms when an attorney has been retained or hired by the probate personal representative. This is a particular form called PC 576. It's a state court administrator form, SCAO, one of the pre-printed forms that's used through the probate process. And one of the nice things about the state court administrator forms is if you look at the bottom corner of that form, you'll see that all of the relevant statutes and court rules are identified that were used to create this form. So let's look at those. We're looking at the bottom right corner of this particular form. MCL 700.3415 and 3502 discuss the difference between an unsupervised informal administration and 3502, which is the supervised administration. 3721 talks about the personal representative's right to hire a lawyer, not just a lawyer, but a lawyer or any professionals, including a CPA, as well as the personal representative charging. It's the general statute that talks about the fact that the personal representative has the right to employ professionals to enhance the estate and charge reasonable fees for those services. Now, that's different from the interested parties in the estate, like the heirs and devisees. If those people desire to hire a lawyer or an accountant or other professional, they have to actually pay that out of their own pocket, where the personal representative gets to have it paid from the top, off the top, from the assets of the estate. So 3721 provides for that, and providing for notice to all of the interested persons of the hiring of that professional. The corresponding court rule, MCR 5.313, speaks specifically to the requirement of what is the noticing to the interested parties of the hiring of a lawyer, as well as the reasonableness of those fees. It speaks that a personal representative has the right to hire a lawyer and to charge, that lawyer can charge reasonable fees for the services on behalf of the estate. In addition, it's a requirement that a personal representative that hires a lawyer must do so with a written fee agreement. Now, in other areas of the law, you don't actually have to have a written fee agreement, but in probate, it is a requirement of MCR 5.313B. That must be in writing. And a copy of that agreement is supposed to be attached to this notice that we're highlighting in this particular presentation. In addition, the court rule provides that that notice regarding the appointment of an attorney or the hiring of an attorney by the personal representative has to occur within 14 days after the appointment of the personal representative. So it is a timely requirement that often does not occur, and it's really unfortunate because it is a mandatory requirement as part of the appointment of a personal representative. So included in the notice of appointment and duties of personal representative, that notice regarding attorney fees would also need to be served upon the interested parties and a proof of service having been completed and filed with the probate court. Let's walk our way through the document. You identify the county, the file number, and as you can see, the court address is supposed to be added at that top part. In addition, it talks about how the personal representative under that court rule 5.313 is required to provide that notice within 14 days. Here, this next section speaks of the estate name, and it's saying, hey, we're giving notice to all the interested persons that could be affected or impacted by that hiring of an attorney, and that there is notice that that personal representative has retained an attorney, and that a copy of that retainer agreement or representation agreement has been attached. So if you get one of these notices and they fail to include a copy of the representation agreement, you have every right to object and demand a copy, because as an interested party within the estate, you have the right to know with full transparency what's going on. This next section talks about how the statement for services will be made. Is it a monthly billing? Is it quarterly? Will it be paid at the end? And you have a right to all of the statements. So you can demand a copy of all those statements from either the attorney or the personal representative. This is sometimes counterintuitive because the attorney is representing the personal representative. But in this particular case, the person has the right to the copies of all statements and can make that request. This next section again identifies the frequency of the billing. Will it occur monthly, quarterly, or in some other manner? And then section 4 and 5 provide for the right of the interested person to object to the rate, to object to the manner, to object to, for example, the reasonableness, or to the fact that they're not getting information or notices in regard to those expenses. So again, it gives you the right to file objections, whether it's in an unsupervised administration, of which the probate court maintains jurisdiction, or a supervised administration in which the court is really more involved in the steps of the administration. You do so by filing the requisite rules and paying the $20 filing fees as part of that objection. The lower section is simply the fiduciary's information and the attorney's information that's included in this particular document. It's really important that you understand your rights when an attorney is involved, because when you're an interested party, you can also often feel as if you lack an understanding of what's going on in the administration. This gives you more information and you should demand it. At the Probate Pro, we are passionate about probate-related issues. If you have questions regarding the notice regarding attorney fees, or if you're interested in hiring a lawyer to assist you in a probate-related matter, or if you just simply want to talk about probate-related issues, visit us at theprobatepro.com or call us at 833-PROBATE.